Good morning and welcome and thank you for joining us for our next installment of Franczek's monthly webinar series on pressing matters facing schools today. I am Amy Dickerson and I am joined today by my partner and the co-chair of our firm's education practice team, Nicki Bazer. Nicki is a former general counsel of the Illinois State Board of Education, and today Nicki will be taking us through an overview of the basic duties and responsibilities of board members and the key school law issues that every board member should know. We hope that today's webinar will provide a helpful primer for new board members and a useful refresher for veteran board members and school administrators listening. Before we get started, there are just a few housekeeping items that we'd like to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Everyone logged into today's program will also receive an email that includes a link to the recording of the webinar as well as the presentation. With that, let's go ahead and get started, and I will turn it over to Nicki.
Good morning and thank you. And first, congratulations to all of our newly elected or re-elected board members out there. Many of you will go through more extensive new board member training coming up and other trainings including the Open Meetings Act. What we're hoping to do today is just give you a bit of the basics to get you started as you guys proceed through your first term. We'll go over board duties, board meetings, access to information, Ethics Act and conflicts of interest, collective bargaining, teacher employment, and student matters. All right, let's just jump right in with the board member duties. The overall duty of a board member is to implement policies that will then be executed by the superintendent and the superintendent's administrative staff for the best interests of serving the students and of the community. Really, your goal as a board member is to direct the purpose and goals of the school district, to seek and engage with the community on what they hope and expect for the school district, and to monitor the performance of the school district and of the superintendent and the superintendent's staff. There's some very specific areas of board governance that you will be as a board member responsible for. First, electing officers of your board, the president, the vice president, the secretary. Fixing the time and place of board meetings, reporting on any Freedom of Information Act requests that the district receives, preparing the annual school calendar, and generally providing governance to the superintendent. You will also have responsibilities in the area of contracts, so awarding contracts after public bids, approving the employment agreement with the superintendent, improving the collective bargaining agreements in your district, and improving any settlement agreements, as well as any contracts for goods and services that are not otherwise, that authority is not otherwise delegated to the superintendent or the staff. You're also generally responsible for the finances of the district, so approving the budget and the levy each year and approving district expenditures. You will also, as a board member, be involved in personnel decisions. So again, making employment decisions related to the superintendent, evaluating the superintendent, appointing all teachers and staff and fixing their salaries, as well as reporting on annual teacher and support staff rifts or reductions in force and reemployments. You will have authority over the real estate in the district, maintaining school district facilities, and determining if you at any point need additional properties or need to sell properties of the school district. And finally, of course, your focus is on students as board members. So you will implement various policies that directly impact and govern how students work and move throughout the district. You'll establish attendance centers or schools. You'll be involved in students' suspensions and expulsions, which we'll talk about a little bit later in the webinar. And you'll oversee the duties of the superintendent as it relates to student achievement and growth. The superintendent, of course, is responsible for then implementing the policies and direction that you as board members set and meeting the goals set forth in the superintendent's employment contract. It's very important and key to remember as a board member that you have no authority individually except your vote on board member matters. Unless specifically directed to by the entire board, an individual board member cannot speak on behalf of the board. So your actions are as a collective, and so that is a key element to remember as you start to exercise your board member duties. Okay, we'll talk a little bit about board meetings, which will be a huge amount of the time that you spend as a board member will be in your board meetings. We're going to talk, your board meetings are governed by the Open Meetings Act. As a board member, you will participate in and pass your Open Meetings Act training. But I want to talk a little bit about some of the sort of key issues that you'll see in board meetings. First, we'll talk a little bit about quorum and attendance, public participation, and communication among board members, including emailing. So attendance, the keys to remember here are that the Open Meetings Act requires that a quorum, which is the majority of the board members, be physically present for a meeting to be in session or to continue. So unless the statute provides otherwise, when a vote is taken upon any measure at a board meeting and a quorum is present, a majority of the votes of the members voting on the measure shall determine the outcome. There are some specific exceptions to that, but generally it will be a majority of those who are in attendance. You can, under certain circumstances, participate remotely. The Open Meetings Act provides that when a quorum of board members must be physically present at any open or closed session meeting, you can have members participate by video or audio conference. If you are unable, you should check your board policies, but generally the Open Meetings Act allows board members to participate remotely if they are unable to attend because of personal illness or disability, employment purposes, or the business of the board itself, a family or other emergency. The board member who is going to be absent must inform the secretary in advance, and the board members who are present and form the quorum at the public meeting must vote on whether or not to allow the absent board member to participate remotely. So there are some circumstances, but generally speaking, the requirement of a board member is to be physically present for a board meeting. One of the areas of board meetings that we get the most questions about probably are public participation. So public participation is the section of the meeting in which members of the public can stand up and address the board. The school code specifies that each regular and special meeting, members of the public and employees of the district must be afforded time to comment or ask questions of the board subject to reasonable constraints. So the board can impose reasonable limitations on public participation, and it is likely that your board policy sets forth what those limitations are. So I would encourage you to take a look at those. The most common type of limitation are time limitations. So what you will find in most of your policies or as practice is that the board limits the time of each individual speaker to somewhere between 3 and 5 minutes. This is important because while public participation is a key element of a board meeting, the primary job of a board in a board meeting is to get the work of the public body completed. And so we do encourage boards to set limits on the amount of time each individual speaker has, because in that way they can control the flow of the meeting and ensure that all of their public business is done.
Nicki, if a public participant begins criticizing school district employees during the public participation portion of the meetings, can the board do anything to stop that or limit that speech?
That's a great question. Thanks, Amy. We do actually get this question a lot. And the general answer is no. The members of the public are allowed to criticize. They have the First Amendment right to criticize school district employees, certainly administrators, certainly members of the board at a public meeting. We do suggest that if a member of the public stands up and is criticizing an individual school employee by name, that the board president encourage that speaker to provide the complaint in writing, to use the uniform grievance procedure or other complaint processes set up by the district to express concerns about an individual employee. The goal to be to sort of curtail that kind of public discussion, but ultimately it is the right of a member of the public to express their concerns about public employees. If someone starts to get into really obscenities or won't sit down after their time is up, then the board can step in and remove the speaker. But if they're simply standing up to criticize the school employee, there's not a whole lot the board can do other than obviously to sit quietly and listen. And that leads me to sort of a final point on public participation that I think is important to note, which is it's really a time for hearing what the public has to say. It's not a great time for the board to engage in a back and forth dialogue. We really encourage boards to sit and listen to public participation and not to enter into a dialogue with public participants. If there is an issue that is very specific to the individual or the individual student, we do encourage the board president to identify a school administrator that might help that public participant sort of get through that issue or resolve it more fully. But other than that, we really do encourage board members just to listen and absorb the information that they're receiving. The last part of this that I want to talk about in relation to board meetings is communication. So it's important for board members to remember that a meeting under the Open Meetings Act includes any gathering, whether in person, conference, telephone calls, electronic means, or any other means of a majority of the quorum of the board. So for board members who are on 7-member boards, that means any 3 board members that get together are considered being in a meeting. And so you do need to be careful when communicating, because there should be no 3 board members ever communicating about the public board's business without it being an official meeting of the board. This is important when you're face-to-face, in person, but it's also an issue over email. So the Open Meetings Act now considers a contemporaneous email communication between a majority of a quorum of the board members as a meeting. So when you're emailing with board members, oftentimes, a superintendent might send out an email to all board members. The board members should be careful not to start replying all, because once they start engaging in that communication over email, if it is a majority of the board, of the quorum of the board, so over 3 members, then they've engaged in a communication that really should be public. And so we really do, again, encourage that any communications over email are done just between 1 or 2 board members, or the communications are discussed during a public meeting. All right, I want to turn now to the issue of access to information. So, and I want to talk about this in a couple of different ways. First of all, what we want to remind board members of at this point is that the Freedom of Information Act, or FOIA, does govern the school district. And so what you create, the documents that you create, may be subject to public view under FOIA. It also, the board and the school district is governed by the Illinois School Student Records Act, or ISRA, and its federal counterpart, FERPA. And so that means that any discussions of students that you create in writing may also create a student record to which parents have the right of access. So what this leads us to is sort of the warning or the reminder that any documents that you create, any writings that you create, emails or otherwise, that involve school district business or specifically involve students, could be subject to either public disclosure under FOIA, or in the case of students, to as a part of their student records to parents. So certainly remember that when you're creating records. Also, keep in mind a lot of board members use their personal email addresses to conduct public business. We certainly encourage you to use a school district email address, which presumably you will be provided by your school district. But even if you use your private email address, any emails that you conduct that involve school business will be subject to those laws. And so we, as your school attorneys, might end up having to comb through some of your private emails if we get a FOIA request or a Student Records Act request, and we know that some of your emails might be responsive. So again, best practice is to only use board emails if at all possible, but just be aware that if you are using your personal email, we may indeed need to see those should we get a request. I also, so just keep those caveats in mind. The other thing that I wanted to mention about access to information is access to information that board members may have of information within a school district. Certainly board members may review records and other appropriate documentation so that the Board of Education may make informed decisions on any particular matter that's in front of it, so a student matter or an employee matter. However, otherwise, an individual board member has no greater rights to access information in the school district. So just because you're a board member doesn't mean that you have access to any student records within the district or any employee records for that matter. Again, if there are issues related to an individual student or an individual employee that are coming before the board, and you need access to that specific information in order to make a decision on whatever matter is in front of you, absolutely you'll have access. But generally, you will not have access to student records or employee records or other records unless you have reason to have that access.
Nicki, we have had a question come through, I think relating to the question about when board members are gathered, what constitutes a meeting, and whether it's the fact that it's a majority of the quorum. And so the question is just in terms of the number of board members, then it actually constitutes a meeting if it's 3 board members or 4 board members.
Right. So a meeting is a majority of the quorum, which is 3 members of that board. And of course, if you have friends on the board and you're getting together to talk about your personal lives and your travels and all of that, that's fine. It's just the issue comes up when you're talking about school district business. Great questions. Okay, so we're going to move on now to talk a little bit about ethics and conflicts. Again, this is a big topic. We're just going to touch on some highlights for you all. But I do want to touch on those so at least you have a little bit of a roadmap. So first, gift ban under the Ethics Act. So the Act prohibits any public officer or employee, board member, or your spouses or significant others or any family member living with you from intentionally soliciting or accepting a gift from any prohibited source. So a gift is any discount, entertainment, cash, food, anything of value that you're receiving that's not generally available, and we'll go into that in a little bit. And a prohibited source is someone who is either seeking official action from the board, seeks to do business or already does business with the board, conducts activities regulated by the board, is a registered lobbyist, or has anybody who has any interest which may be affected by the performance of the official duties of the board member. So obviously if you receive a gift or someone solicits you about receiving a gift and you're not certain whether it is a gift or whether they're from a prohibited source, certainly consult with your attorney. There are some general exceptions to this. Again, opportunities and benefits that are open to the general public. So for example, if a local business is offering a discount, generally you can certainly access that as a board member. It's only if they offer you that discount individually and specifically because you're a board member. Anything for which you pay market value is fine, obviously. Certain kinds of gifts from relatives or family friends are fine, and there's a number of other exceptions. Food and beverages not to exceed $75. So again, if there's an issue that comes up where you think you might receive a gift or you've received a gift, please talk with your attorney. And never fear if at some point you receive something and then you start to panic, oh my gosh, I shouldn't have accepted this. If you promptly take reasonable action to either return the gift or donate its equivalent to a charity, then you will be relieved of any violation of the Gift Ban Act. So again, lots of folks out here to help if you do end up in that situation. The other area of conflict or ethics that I wanted to touch on is that both the school code and the Illinois Public Officer Prohibited Activities Act prohibit school members from having any interest in any contracts of the district. So there are several exceptions to this. And again, if you have an interest in a contract that is currently before the district, certainly consult with your counsel. But if the board member has 7.5% or less interest in the company, that's okay. It's really when you start getting above that that you have a problem. And the issue with this is if you own a company that's doing business with the board, it is not a matter of recusing yourself from the vote, it is an absolute prohibition. So you either have to, the district has to end the contract with your company, or you have to step down from the board. So it is important that if you do have a company that is engaged in business, again, there are a number of other exceptions to this, so you should seek out information, but definitely keep that on your radar. Okay. All right, we are going to now, I know we're sort of whirlwinding through all of these topics, but we're going to talk a little bit about bargaining and employment. So as board members, you ultimately will be responsible for approving any collective bargaining agreements between the district and whatever unions you have within the district. So the first suggestion or guidance that we would have for you as new board members is to become familiar with the different units within your school district. So some school districts, just their teachers are in a union. Others have their support staff unionized. Some are in one union, usually referred to as wall-to-wall. Others have individual units. So it would be helpful to become generally familiar with the unions, the employees that are unionized within your district when you come on board as a board member. Participating, if your district is engaged or about to be engaged in collective bargaining with any of your unions, it is a great way for a new board member to get to know the issues in the district, to become familiar with the ins and outs of the budgeting process, to become familiar with the general policies that govern your unionized employees, to be familiar with some of the staff that are at the table. I will caution, though, that it is a very large time commitment in some cases. Often it takes some months to negotiate a collective bargaining agreement. Sometimes those are very long meetings. But certainly encourage any board members who have an interest to seek out that opportunity. Also, for those of you who come from the private sector and maybe have some familiarity with private sector labor negotiations, I will also just caution that public sector union negotiations are different. They're governed by different laws. Specifically, they're in the school boards are governed by the Illinois Education Labor Relations Act and a number of other rulings and Supreme Court decisions that impact public sector labor unions and not private sector. So again, if you're coming from the private sector, I think that experience will be very helpful, but again, caution that it's a little bit of a different terrain within the public sector. So turning towards employment, again, the school board is ultimately responsible for employment decisions within the district. So you will see employment issues coming before you. One of the things that we thought it might be helpful to understand just sort of up front is what is tenure and how do teachers receive it? So tenure is a process by which a teacher works in the district for a certain number of years and obtains tenured status. So prior to obtaining tenure, a teacher can be dismissed in a much more simplified and streamlined version. It's basically a non-renewal. And up until the last year of their probationary time, a teacher can be non-renewed for any reason that's obviously not prohibited by law. In the last year, it is the same, except that they do need to be provided a reason. Most of our districts provide reasons to probationary teachers regardless of the year in which they are non-renewed. But it is important that your districts and your superintendents are keeping a close eye on your probationary teachers, because if there are issues or concerns, it's best to address them prior to the teacher obtaining tenure. The tenure rules in Illinois have recently changed under what we refer to as the PARA law. So in the past, and for most teachers, they will receive tenure after their 4th year teaching the district. This is not something that you vote on. It's an automatic process whereby if a teacher has taught in your district for 4 years, they will automatically obtain tenure. There are now some avenues where a teacher may obtain tenure earlier than 4 years. So again, you'll hear all about this in sort of more in-depth board trainings, but we did want to make you aware of the fact that the tenure rules have changed a bit, and it will impact your district going forward. All right, we are rapidly running out of time, so I'm going to shift directly to student matters, and I'm going to highlight just a few student matters quickly for you all, and particularly where they intersect with you as board members. So the first area I want to talk about is student discipline. So the board is the only entity that has the authority to expel a student. In most districts, the way this will occur is that there will be an administrative recommendation to expel a student. There will be a hearing. Sometimes the hearing is in front of the board. Many districts use an independent hearing officer. That hearing officer will write up a report for the board setting forth the facts of the expulsion matter. And then the board ultimately has to make the final determination as to whether to expel a student. Under Senate Bill 100, which is what we call the relatively new student discipline law in Illinois, the board must determine if the administration has met all of the elements for expulsion. And they must issue a decision detailing the specific reasons why removing the student from the learning environment is in the best interest of the school, and also as to why they're expelling the student either for 1 or 2 years. The limit on an expulsion is 2 years. Often boards will, if they do expel a student, will then defer the expulsion and send the student to an alternative school, either run by the district or run by the Regional Office of Education. But that is the authority and the sole authority of the board. For suspensions, the administration may suspend a student for up to 10 days without board action, but if a student appeals that decision, then that too will come before the board in a similar way as an expulsion after a hearing and a hearing officer report. So you will, as board members, from time to time receive student discipline matters before you. Again, you are subject to all of the confidentiality and privacy laws that govern when you go through those proceedings, and ultimately you will make those decisions. One of the other student matters that you may encounter as a board member is in the area of special education. Again, your role in this will be limited, but it is helpful to understand that the school district has requirements under both federal and state law to ensure that students with disabilities have full access to the educational program within your district. And for some students that will be under IDEA and the school code, and they will have individual educational plans or IEPs. For some students that will mean Section 504 plans. Again, all of these are very complicated areas of law, but the key for you to understand is that you as a school district are obligated to serve students, and that those services will depend on the needs of the individual students involved. So each individual student's needs will be addressed by the administration, by the special ed director in your district, as well as the individual special education teams that operate at your school buildings. You may, from time to time, hear about some of these matters if there is a dispute between a parent and the school district as to what services and where those services are provided for the student. And if a parent files an appeal of the district's, of the IEP team's decision through the due process or administrative appeal process, those will likely come to your attention as board members so that you understand sort of what's happening within the administrative procedure. Those also can be appealed to the federal courts. So again, likely these will come to you as if disputes arise between parents and the district, you will be informed as board members as to that process and potentially any resolution of that process. The only other item under student matters that I just wanted to touch on briefly is just to remind board members of the rights that students have within your building. While not coextensive with the rights of adults walking around on the street, students do have constitutional rights within school buildings. They have First Amendment rights, they have Fourth Amendment rights. Those are the two that come up, I think, most often in discourse. Certainly, First Amendment rights have been on the front burner of issues that school districts have faced over the last few years, walkouts, kneeling at sporting events. If you have those issues, we do encourage you to seek out guidance from your school council. We certainly have advised many boards on the ins and outs of the rights of students within schools. The key to remember here, is that students do have those rights within school buildings, albeit in a refined format. And so we do have to be careful as we board members move and take action within school buildings regarding students of those rights and the needs of students in those buildings.
Nicki, we've had a couple questions come through, if we can try to briefly touch on them. One is going back to the issue of communications between board members and being mindful of when the OMA or FOIA may be implicated if there are 3 or more board members involved. And particularly the question is relating to text messages and whether text messages should be treated the same as email communications.
Yeah, so there's not been a huge amount of guidance on text messages. So our guidance is always to be cautious and sort of, be overabundantly careful. I would say yes. Certainly if you are texting with 3 or more board members, that will indeed be considered a contemporaneous conversation and would be unlawful under the Open Meetings Act. Certainly any text messages could also be subject to FOIA, even if you're just text messaging one board member. We certainly have seen already a ruling where if board members are texting during board meetings, that those text messages are indeed subject to FOIA. So yes, I would say any communications over text messages that are between 3 or more board members would be considered a meeting. Those are definitely contemporaneous communications. And again, caution, even if it's less than that number, subject to FOIA.
Okay, and then one final question. I think we just have time for one more. For any newly elected board members or those who were reelected, if someone was helping them campaign who also happens to sit on a school committee, if the elected board member would like to purchase a monetary gift for them as a way of saying thank you, do they have to be mindful then of the gift ban issues that you described earlier?
So again, just to be clear, the question is if the board member actually wants to give a gift rather than receive a gift for services, yeah, I would definitely be cautious. Obviously, you can certainly give a gift as a board member. The issue really is board members receiving gifts, because that's the concern is, sort of a pay-to-play kind of, you get a gift and then you approve a contract. If you want to give a private present to someone who has helped, I understand that they're now on a school committee, but if you want to give a private gift out of your own money, out of your own funds to someone who's assisted with your campaigning, you can absolutely do that, as long as it's clear that you're doing it as a thank you for their previous work with you.
Great, thank you. So it looks like we are just about out of time. Thank you, Nicki, again for going through all of these issues for board members. We hope that you found today's webinar very helpful, and thank you again for joining us. The next webinar in our monthly series will be on June 18th, and we will be discussing trauma-informed schools, and we'll be joined by a special guest, Julie Schellberg from the Partnership for Resilience. So we hope you can join us for that webinar. You will also receive an email today, as I said at the beginning of the program, with a link to the webinar today, the recording, as well as the presentation, and a link to register for our upcoming webinar. Thank you again, and have a great rest of your day.